And I will state at this point, I do object to Mr. Wiley representing the board on the basis that he is a board member, not an employee. And for him to have been appointed as representative, it's my understanding that it should have been done in a regular board meeting as an agenda item, according to our legal advice. So I'm just putting that out there for your knowledge.
But other than that, you're prepared to go forward?
I'm prepared to go forward.
Okay. All right, so we're gonna call this meeting to order. The microphone is on, okay? Today's date is June 27th, and it is 1:25, and we have a quorum. Do we have is it the signed protest number here?
Madam Chairperson, there are a number of protests.
Well, I'm not asking for the protest, I just want to know if we have a protest number for the entire thing.
That's their number, but 65 is...
65 is the case number.
May I ask a question?
Yes.
I'd like to request information from our attorney representative such that we have authority to go forth of dealing with someone other than who is written here as authority. Do we have the authority, Kevin?
Oh, that's Charlene right here?
Yeah, I know, but she's not going to speak. That's who said it.
They removed her and they've appointed you.
So my question is for our attorney.
Yeah, I can't answer that for you. We would have to seek counsel from your attorney.
I personally I am not ready to go forth unless I know that our
Can you make a
attorney
phone call?
is in compliance with that we have the
I
authority
can
to
call
do so.
my attorney, but then we would have to get the other attorney that has given you all advice in the past. My attorney can't not give you all advice, so there is a third attorney that has to get involved in this at this point.
Because we don't work for you, meaning the office.
No.
So we're not under your attorney.
No.
We're under our own attorney.
Correct.
What she's saying, you know, just
I don't know
switch it in
that
the middle of everything.
Well, if the attorney says we may waive it or whatever, that's okay with me. But that's our attorney, not
So,
their attorney.
Charlene, you're not prepared to present this?
So let me be perfectly honest. I just started in April. I don't have enough information to make factual, to give out facts right at this moment. So I'm still learning. I am relying on Lisa, John Wiley, because they've got the information, they know the boards, they know it better than I do at this point in time, though I'm the GM. And so at this point, I am learning from them, and I just want to make sure that we make the right decision, say the right thing, and give the correct information. Does that make sense?
Yes, ma'am, perfectly. That's exactly where I'm coming from. You have made yourself clear. The attorney's here. He's a board member. He's objective. He's supported by their attorney. We have no say-so right now, in my opinion, to speak or go forth with this until we clear it with our attorney. Since this is at the 11th hour, like he said, he wasn't notified, but neither were we until we sit down today in this very minute. I'm not comfortable. Just personally.
So, if I may, I think the protocol under the property tax code is a property owner has the power to appear for the protest, regardless of the representative that appears for them. The jurisdiction of the board is to issue an order. And in fact, I could file a lawsuit and within 120 days amend that lawsuit to correct the name of the property owner, add a new property owner, whatever the case may be. I mean, I think the statute is liberally interpreted at this point to allow the board to make a ruling. If the board does not feel comfortable from a jurisdictional standpoint, then I think the remedy is likely an extension. You extend 30 days out, you give everyone a chance to consult with whomever they need to consult, and we reconvene. In the absence of that, I think the only authority the board has is to rule today. And then if he takes objection to that board order, then there's a remedy under the property tax code where he can seek an amended order. But I think those are effectively the options, in my understanding.
Well, everyone that's come before us in the past, and I'm saying several years, we've always known the property owner in this case will be accompanied by attorney so-and-so. And I don't have any objection to you as an attorney. You're following the protocol that we've undergone before. Where the question is placed by the tax office is his position to speak, based upon who signed the paperwork that we have before us. And that's the only reason I am inquiring as to should we go forward.
Mrs. O'Brien asks,
Yes, right.
whether it was me or Jesus sitting here, the facts are still the facts. And so, regardless of whatever of the 300 million people that live in the United States sit here, the facts are still the facts. Your ruling is based on those facts. It's not based on who is sitting in this chair answering questions. It's based on factual information that you receive and then deliberate on and make a decision.
Well, and I agree with you to a point. And my question is, back on May 29, 24, did not the board know that you would be sitting here instead of Ms. Cavender? She signed it. That's why I'm asking.
I think it was in its infancy there as to who would be sitting where. And at that time, we had not received legal counsel to the extent of who would need to sit where, and we're following the advice of our legal counsel.
Section 5 says, in person.
Yeah,
I just saw
I
something
just stated
that I will be attending the hearing.
from my legal advice.
I'm sorry.
From my legal advice was if an employee they can represent. If it's a board member, they have to have prior consent from an action item on an agenda from a regular meeting or one of the board members to represent.
Is that a statutory code section in the property tax code that you're?
That was advice from my attorney. So
Because this, if you read this, to me, this on page 2, it says that Charlene is the one who's to present.
And I'm sorry, man, for the purposes of the record, what do you?
I intend to appear to the ARB hearing scheduled for my protest in person.
And I believe she's speaking as a representative of Fort Clark at that point. Fort Clark is the owner, not, I'm sorry, Charlene.
Right, that's my calendar,
I mean, she only can act in her capacity as
general manager.
general manager of Fort Clark.
and that's what I understand. But what authorizes John Wiley to be the representative?
At the 11th hour. And
Right.
that's where I'm coming from.
That's the
I have
question.
no objection to him or Jesus sitting there. But at the 11th hour, to me, your paperwork, their paperwork, our paperwork should be A, B, C, D. To the letter, to the dot, period. And it doesn't read his name. I'm uncomfortable. I want to hear from our attorney.
May I offer a solution?
Sure.
It's my understanding that generally these meetings get 5 to 10 minutes. If everybody would like a resolution or move forward today, maybe a solution would be that we have a little liberty in that regard so that Ms. Cavender is able to sit here and give as much of a factual statement as she can, and a little more liberty with our attorney to answer more proper questions or frame questions. Are you comfortable?
Let me give an example. I had not a similar issue, but an issue come up in front of the Railroad Commission not more than a month ago. Okay? What the administrative law judge did in that proceeding was she conducted the hearing, she made the record, and then she deferred a finding until she consulted with whomever she needed to consult with after the fact. Since we're all here, that keeps everybody from either having to sit here for an hour or however long everyone consults with their attorneys, which may take God knows how long. how long, or coming back in 2 weeks and knocking this, back further down the appraisal district's calendar. We make our record, we put on our evidence. The board can defer its ruling until it gets an answer on that question. And if the answer is Mr. Wiley doesn't have the authority to testify at that point, well then I guess the only option is to come back and do it all again. But at least we have everybody here, we make the record while we're here. That leaves you options. That would be my suggestion.
Todd? What do
You have
think?
my
What-
objection.
You have, okay, so we had two objections, you and.
Just a vote, one vote.
And
I'm going.
so, okay, so I think at this point, we would like to put it off, schedule it for another time,
Understand?
which is gonna get us into August. After the 9th of August,
That's an issue because of scheduling.
so. Charlene, you don't feel you can answer these questions? I'm sorry, I should call you.
It's okay, it's all right. May I be frank? Okay, I just started in April. There's a lot to learn about Fort. Do I want to say something incorrectly and not say the right thing? No, I don't. I am relying on the board members to teach me what I need to understand. And I trust John Wiley very much, and there's still a lot I have to learn. I don't want to say the incorrect thing, the wrong thing, because that's going to be on record then that I said it incorrectly. I'm giving him my,
Proxy?
yes, because he is the one that has the information that is going to be correct. I just feel that, I mean, we're all here. Everybody knows most everybody here other than me that well. He's not going to say anything that is incorrect. He's going to give the truth, and he's going to give the whole truth. And like he said, it's going to be based on facts. And I trust him tremendously. Regardless of how it's voted, he's going to give the right information. And I just, we're all adults. We're only going to listen to the facts. I don't see what could be wrong with that if he's speaking on my behalf so I can learn from this whole situation as well.
Okay. Wanda, you haven't said much. How are you feeling?
Well, I really, tell you the truth, I don't know. I hate to put it off, but like you trust John, I trust Cordy, and I'm kind of new on the board also.
See, so you know how I feel. Right.
I
Would it hurt to listen?
It would hurt to listen.
Would it?
I don't know. Todd's feeling that way.
I mean, Todd, do you really think it's...
It's a procedural issue. Under
Okay.
legal advice, I was told that as a board member, they needed to be nominated by their board in a regular board meeting as an agenda item that needed to be voted on
That was told to you
by
by
my legal counsel.
legal counsel.
As an employee, she's under a different situation. But if a board member is to represent, then the board has to invest in them at this point. Because of the legal advice, in my opinion, he cannot duly represent the board because correct actions on their behalf have not been taken.
Okay. I think with that said, that we should postpone this till what date?
We hear from our attorney.
Or we hear, or, well, both.
Well, we could call our attorney right now and see what our projected time of wait will be. We have till 5 o'clock. I don't want to sleep
I
until
don't,
5 o'clock.
if you wanna try that, I don't have a problem with that.
I don't have a problem with that if you,
But if,
Unless the attorney lets us know I'm not available till tomorrow to talk to y'all.
So for the purposes of the record, if the board finds that Mr. Wiley at this time is not allowed to testify, then I think that our only option at that point would be to request a continuance. Because I think it's important for Mr. Wiley, given, Charlene's testimony,
right.
her lack of
Experience.
subject knowledge,
Yeah.
that Mr. Wiley be allowed to testify, even if we have to follow the procedure outlined by Mr.
I
Tate.
don't think that's unreasonable. Yeah.
No, I don't think that's unreasonable either.
It's not anything we want Mr. Wiley to take personal, we
No.
have to do this by
I'm
the
just going
rules.
by a signed document, that's all I'm getting at.
Yeah, so, do you wanna try and get a hold of somebody?
Not him, no, our attorney.
Is it Todd that's gonna get a hold of our attorney?
I will contact my attorney so that we can get the appropriate attorney for your legal advice. We've contacted him in the past.
Yes, we have.
Okay, so it's all a matter of timing, whether we can get him or not. So do we wanna postpone this for what? Hour? Half hour?
No, we're not gonna get the legal advice today. That's the issue.
Unlikely.
Well, maybe, but you know.
No,
have to set up
because I would have to contact our attorney, she would have to do the movement to get him.
Now, we can do this, I can do this on the first or the second, but after that.
Yeah, that's the issue with the scheduling, so.
And I would just request if it is rescheduled, at least 7 days notice.
No, well, at this point, because of their individual schedules, our next hearing is August. So, unless you object to that.
I do not object to that. Whenever it's set, I would just request,
Right.
because I have other ARB hearings.
No, I understand that. You would get your at least 14 days notice prior to. So.
I believe it's August
Is this
15th.
playing in?
And for the record, do we need to resubmit the appointment then?
Well,
I mean, is that your position that?
my position is that at one of their regular board meetings, that the appointment of agent needs to be an agenda item on their regular board meeting and voted on by the board in open session.
And look, the comptroller may be able to weigh in on this. There may be some kind of guidance out there. I'm not sure.
You might be right, but I'm just going from what my attorney told me.
I understand.
So,
Well, excuse me, if they do that, agree to do that, then my objective to talk to our attorney, I'll pull it off
Right.
the table because procedurally,
Right.
the right person is talking to us in front of us because he has signed authority.
Yeah, for the record, I don't agree with Mr. Tate's position. I think the comptroller has promulgated a form. That form has been signed. There's no question in regard to the effect of that form in and of itself. I think Mr. Tate's objection goes above and beyond what the comptroller requires in the form promulgated. So I do object to it. I can be wrong, but for the record, I don't agree.
Would it satisfy requirements if we, have an email vote right now through our board? Because we do not have to do everything in open session. That's not a requirement of state law.
No.
So we can do an email vote to appoint me, and as long as all board members show up, we can provide a document saying that all board members voted, no different than open session, it's the exact same thing.
How many board members do we have?
There's 3 here right now, and we can get the other 2 on the phone and get them to answer emails.
It's up to Todd, he's the one.
No, that's not my decision. I've
Are
given
you
you
gonna be
what
happy with that?
I've given you what my stance is on the legal advice.
Okay, so you wanna continue with what you've already explained. So I would say, I guess not.
Okay.
So I guess if the board did that at this point, it would then be up to the Appraisal Review Board, not Mr. Tate, as to whether he should be allowed to testify. Would be our position.
Well, personally, to answer you from my opinion, I'm not going by what Todd says.
I understand.
I'm going by what Todd says the attorney advised him that he could do. And that's what he shared with us. So that's where my hat goes into our attorney.
Separate counsel.
Correct.
Correct. Right. And I understand that. I didn't think Mr. Tate's counsel represented the board.
No.
I understand. There are different law firms, but it's only ARBs. I've dealt with those.
So, man,
Oh, yes.
so I don't know what Todd Tate's or y'all's attorney is versed in, but we are very versed in property code juvenile Property Code 209 does not say that we have to do everything in open meeting. That is not factual. The law says that we can make decisions as long as every board member has the opportunity, and Linda, you were a board member for a long time, every board member has the opportunity to voice their opinion. We can email vote on certain things of discretion, and then in our next open meeting, we have to vocalize that by saying, on this date, we had a email vote for such and such situation. This was the outcome, and it is a matter of record in open meeting. That is state law. We practice it every day, every week. Essentially, we practice that, and the outcome is exactly the same as open meeting.
If I may, maybe rather than speaking in theoretics, we should recess for 15 or 20 minutes. You can present your email to the board. The board can make a decision at that point, not based upon a theoretical email it might have. Then it has, at least at that point, the board has it in its possession and it's part of it. And it can make whichever decision within its judgment it decides.
Okay.
But that would be a request. You're in charge. Not me.
I'm still looking at, everything is still that wrong. Sure.
What do you think?
Well,
The two of you are in agreement?
no, I agree with what he just said.
What did you say?
That the
paperwork
filled out like it's supposed to be, like what he said. Everything is supposed to be, every I dotted and T's crossed. This is.
I agree with that. I do know that the board does do many email votes. I think they did when you were on the board also.
I'm not objecting to anything.
So
They have said so far.
I'm just saying that I do know that happened.
We don't know that we can go forward with the paperwork incorrectly filled out based upon what we're hearing.
And to be clear, I have the proper paperwork here, which supersedes that paperwork as soon as Ms. Cavender signs this.
Granted, but it goes against what his attorney let him know in the office, time-wise, the timing
Okay, yes, ma'am.
of them being properly notified. And I don't know that we have the authority to, we probably have the authority, and I'm guessing, just to hear it besides you, because we don't work for them. They present the paperwork to us. We hear from y'all, client, and go forth. But the paperwork is not proper.
May I ask a question? What is the timeline of him superseding my paperwork? Does it have?
That's an attorney question that we're going to have to ask.
What did your attorney say, Todd?
There wasn't a question about timeline.
Okay.
It was an issue of if a board member were to represent, they needed authorization by the board.
There, you just said it.
By an agenda item
Okay.
in a regular meeting.
Then we can vote by email because that would be the agenda right there.
And as I
That's
understand it,
exactly
that's
what your lawyer
a
said.
corporations code requirement?
I don't know.
It doesn't
That-
sound like a property tax code requirement.
That was our attorney's opinion. I asked that question specifically, and that was the answer I got.
And does he know the laws for an HOA?
I can't vouch for what laws our attorney knows or doesn't know.
So I can represent that when a appointment of agent is filed, it supersedes the prior filed AOA, and it's automatically revoked. You only have one AOA on file at a time. So the minute that he files that with the appraisal district, the prior one is revoked.
And we could have the email vote.
But at this point, it wasn't filed with us, it was filed with you.
Right.
Right, but I just asked the question if there's a timeline. So I don't see that there is one. If there is one, then that would stop this right now. But if there is not a specific timeline, then his would supersede mine because that's what I'm requesting. And we can have an email vote right now and clear it up. And I'm not trying to be difficult. I'm just looking at the facts as well. If there's not a specific timeline of when he can supersede my request.
And that's
Is that fair?
That's not my decision, that's your decision.
Okay.
It wasn't given to Todd ahead of time.
If I may, I think to articulate what I'm hearing, there are two issues. There's the issue of, is Mr. Tate prejudiced by the filing today of the AOA? And then is the court comfortable going forward with the record as it appears? And those are, I think, the two issues before the board.
I don't think we're comfortable. I think that's pretty straightforward. And in light of that, I think we need to reschedule and you need to straighten out the paperwork.
And understand, it's our position that the paperwork is sufficient for the record, respectfully.
Well, that's all well and good, but if the board won't work with your paperwork, we need to
And I
fix
don't
it.
have a problem if that is true, based upon our attorney. 5 minutes from now, I'll be glad to go forth regardless of what he said.
Right.
But I'm just going by signed signatures and I gotta hear it from our attorney because it's at the 11th hour and I'm not comfortable with that.
I understand. It's my understanding that the board doesn't believe it can get a resolution to that this afternoon and that we need to continue for a number of weeks. Is that the board's decision?
Well, I don't know what their schedule is. They're the ones that set up these meetings. We have 1 and 2 July, correct?
Pardon?
Available,
Yeah.
as far as I know, and
Yeah.
I don't know a lot about it, but we have
Yeah, I don't
July
know.
1 and 2, that's about it. If we don't do it, well, we have tomorrow.
Yeah, but I don't know how rapidly an attorney,
It's gonna call you back.
yeah.
Do you wanna try and work on that this afternoon and see if you can get something for tomorrow or 1 or 2 July? I don't care. I mean, I'm flexible to that extent. After that, I'm gone.
Right. Well, that's your decision, I mean,
What do you wanna do about that? Do you guys wanna vote on that? If Todd can, it's Todd, right? You're doing it?
I would contact our attorney and have her contact the appropriate attorney that she's contacted in the past.
For us.
For them to contact you
Okay,
to deal with this issue.
okay. Whether that can happen
Right.
in the time frame that we're looking at is the question.
Is the board independently represented by counsel or?
Yeah.
The previous times that they have had to have counsel, it's our attorney who contacts an ARB counsel because they don't have a retainer on a specific attorney. So in these situations, the contact has to go between them without me being involved.
So would this be the first contact to this ARB attorney regarding this matter?
Yes.
Okay. Then I think it's unlikely you're going to get an answer.
Right.
That's where, what I'm thinking.
But if we do,
Yeah, because that attorney will contact her
Yes.
if we do an email,
and she in
it doesn't
turn
matter.
contacts us.
And file it, as soon as it's filed, it supersedes.
Yeah, we've made that record on this, and I agree. I think the minute that this is filed, it supersedes the previous. But I think the board has expressed whether they have authority to act based on the timing of it. I think.
I have a question. So the lawyer that is going to contact you is their lawyer?
No.
No.
It's another,
Oh, it's a separate,
right.
okay,
Right.
okay. That's all I wanted to know, okay.
ARB we have our own.
ARB attorney will contact her, bypassing him.
Gotcha.
She in turn will contact all 3 of us, and then we'll contact him. We're ready to go forth.
The problem is the timing of it, that's the issue.
We're merely liaisons between the taxpayer and we don't work for the appraisal board.
All they do is give us paperwork, which we have before.
We look at the paperwork and everybody gives their side and we make a decision.
So one more question, please excuse my ignorance, I'm learning. So if there was the email, okay, right, the vote, and John filed, and it's on, and it supersedes mine, could we then move to have it Monday or Tuesday?
That's up to you guys.
Can you do it if they can get it together and get it done, can you work on it? 1 or 2? July 1 or 2?
I can.
What is next week?
It's Monday, Tuesday.
We got the 4th of July next week,
Yeah,
the 1st and the 2nd.
I can.
in Monday or Tuesday.
Can we go off the record for just a second? So I'm not reading my phone in the middle of the hearing. I just need to check my schedule to see if I'm available
Okay,
next week.
sure. Do we need to turn that up?
I don't mind, I just don't want the board to think I'm checking my emails.
No, that's fine.
August 15th.
You've got 1, 2, and 3, and 5. You're closed here on July.
I'm gone on the 3rd.
Okay, well, that changes everything.
That's why I keep saying 1, 2.
I got you, or the 15th.
Yeah.
Is the 15th
The
not,
15th of July?
it's not open?
No.
July,
I mean,
August.
August,
Oh, that's what I'm
yes.
saying.
Yeah, August, yes.
My bad, I'm sorry.
Yes.
So we have 2 weeks, 2 days next week, or the 15th of
And
August.
we have tomorrow.
Yeah, but
Tomorrow.
it depends on how soon you can turn hold of council.
Yeah, pending council
So, I
conversation
mean,
with her.
at this point, August 15th is that,
Looking
how
like.
does that look for you?
Can we just take a break and let me talk to my client for a second? Would that be all right? Can we get off break?
Do we want to shut that thing off? Okay.
We would propose, we've made our record, we already would just take some action, we understand the board's council. Unfortunately, I'm not available tomorrow or next week, so I would request that if it's to be continued, that it be continued to August 15th, which gives the board time to consult its legal counsel. If the board's decision is that a vote does need to be held, then the board can hold the vote, be it in person or by email, whichever is required, and the record is clean at that point. We don't want an order that is not final for the purposes of the appeal.
And with that said, my question to you would be this. The board making their decision, we don't know what our attorneys will say, but I think I'm gonna ask you to ask him. So they, being the board, need to resubmit this form that I have in front of me, signed by him. If that's the vote, the board, or Clark board's vote for him to be represented to replace Ms. Gavin. This piece of paper. Okay, and have
That's
it
the
to,
property notice, owner's notice of
have it to the
protest.
office. Yeah, the appointment, that's appointment of an agent to him and to your office by what date?
Prior to the 15th.
You want to write it, right, that?
14 days before.
Just prior to.
Okay,
And I think that'd be a function of whenever the board, the Appraisal Review Board receives a legal conclusion or recommendation on that. It may need to advise Fort Clark Springs in some way, shape, or form by letter of what it's requiring at that point. So the record is clear, would be my request.
Okay.
Written notice
Yes, ma'am.
to the board.
to the board of directors?
To the
Or to you.
Fort Clark would be fine, yes, ma'am.
Okay.
I'm just trying to dot all the i's and cross the t's. And I apologize about my unavailability, but I can't do that.
Oh, that's my
Most of
problem,
us are having the
unfortunately.
same issues between now and then, so.
Are we all set? So we'll close this session and hopefully start again in August.
Thank you.
Thank you.
very much.
Thank you all.
Run.